How do we understand efficacy and the potential for unintended consequences? As to efficacy, I make 3 points. Again, Professor Greg Craven, a constitutional lawyer who was one of the experts behind the original proposal for an Indigenous voice, has said that Labor's voice proposal is described it as a con job which is fatally flawed. He said the reality is that you have a situation where any person who wants to create difficulty for a government over its decisions can now end up going to the High Court. It will be very, very difficult for government to operate, either because it will be constantly delayed and tied up in knots, or indeed because the courts end up intervening directly in decisions. Secondly, in an era where we recognise the importance of hope, embedding this new head of power in the Constitution says to some of the most marginalised in our nation that they are and will continue to be different from everyone else, and they'll need this permanent additional help forever. And as highlighted by Senator Nampijinpa Price in question time today, this top-down, Canberra-centric approach does nothing to help Indigenous communities on the ground who want local solutions to build better lives for themselves and their families. But importantly, one of the greater unknowns is what happens in advance of the Parliament and government departments making decisions that affect Indigenous Australians. Even lawyers and judges can't agree on what this may mean. So if there's a constitutional right to give advice and to be consulted, what that means is that government has to reach out to people to consult and provide time and finance to actually help them understand if there's a case that they want to make a representation on. If they don't do this, then constitutional rights will have been breached, opening up the government to both constitutional and administrative law litigation. Some of my colleagues here have quoted former High Court Judge Callanan and others who foresee a lot of disruption. Some have quoted High Court Justice Robert French, who said, look, given the immense range, there might be an interaction and it would make government unworkable. I don't think the High Court is in that business. But the Honourable Roger Giles, AOKC, says that neither the government nor any expert can give those unequivocal assurances. And we don't have to look far to see an example of how courts do in fact act in this exact space of imposing their interpretation on what consultation means in practice. Just December last year, following an action led by the advocacy network known as Environmental Defenders Office, the full court of the Federal Court of Australia upheld a judgment setting aside a decision of the National Offshore Petroleum Safety and Environmental Management Authority, NOPSEMA, to approve an offshore gas project in the Timor Sea that had been submitted by Santos under the Offshore Petroleum and Greenhouse Gas Storage Environment regulations. Why? Because the court determined that the consultation with an Indigenous clan had been inadequate, despite NOPSEMA and Santos highlighting that they had met all of the relevant defined regulatory requirements. The court held that the extant view on the scope of consultation was too narrow and that the clan had functions, interests and activities which may be affected by the project and so should have been consulted. The EDO, the media release put out afterwards, celebrated the fact that this legal action and the judicial decisions to broaden the requirement for consultation would slow down, if not completely stop, this project, which is one that would increase energy supply to Australians, helping to drive down the cost of living. So judicial intervention and unintended consequences that affect life for all Australians are not an abstract concept, but a real risk if Australians vote yes in this referendum.